Sorry to cut off what I'm sure is wonderful. But we want to make sure that we plenty of time at the end for questions, so I got to get us started relatively on time, right? So welcome to our talk today. I'm Shannon Raisler, faculty member here at the law school, director at the Environmental Law Initiative. And if you will indulge me, I have just a couple of announcements before I introduce our speaker, and I promise I'll be brief. And I also want to say thank you to Blake Group, right, for organizing all of this. And to Fred and Sharon, as always, for their generous support of our programming with the initiative here at the law school. So the first announcement, which you may have seen if you are a consumer of our website or on email list, right, is that we've hired a new director of the Hubbell Environmental Law Initiative, Jennifer Terry. And I just want her to kind of wave. You see her? She's an alum of Iowa law and brings more than a decade of experience in environmental law and policy to this position. We are super excited about the energy and expertise she's going to bring to Healy programs, collaboration, and policy research. So you'll be seeing her in the coming weeks. And I just wanted to announce and get her face out there, right? So you all know who she is. Thank you, Jen. Thank you. Second, I want to highlight a couple of upcoming events. Today's talk, delivered by Gardner, is the first actually of 3 events this month alone on water quality, sponsored or co-sponsored by Healy. All of our events are detailed on our website, healy.law.iowa.edu. It's pretty easy to find. But just to give you a taste of what's to come, on Wednesday, October 29th, Healy's co-sponsoring an encore presentation of findings from the recent Central Iowa Source Water Research Assessment Report, which I think people are shortening to CISRA, right? A scientific study that provides the most comprehensive analysis of water quality in the Des Moines rivers to date. Healy's new director, Jen Terry, was the project lead for this report, commissioned by Polk County, and we're delighted to continue the conversation that this report has sparked. The event will begin at 6 p.m. at Big Grove. Again, details on the website, so you don't have to remember. That's October 29th. The following day, October 30th, Healy's hosting a panel discussion here in the Boyd Law Building, exploring how states, communities, and advocates are responding to the regulatory and policy uncertainties around the EPA decision that you're going to hear Professor Gardner talk about today. The panel will focus on wetlands and water protections across the Mississippi River. We have folks from Tulane coming to talk about the Mississippi watershed from Iowa to the Gulf. Again, details on the website. Finally, I would like to introduce today's speaker. Professor Gardner is an internationally recognized expert in wetland law and policy. His research and scholarship focus on U.S. and international wetland legal and policy issues with an emphasis on biodiversity offsets. He's lectured in Africa, Asia, Europe, and North and South America. Very impressive geographic reach. He directs the Stetson Institute for Biodiversity Law and Policy, which received the American Bar Association's Distinguished Achievement in Environmental Law and Policy Award. He is also the recipient of the 2018 President's Service Award from the Society of Wetland Scientists and the 2006 National Wetlands Award for Education and Outreach. He's also served 2 terms as chair of the Scientific and Technical Review Panel of the Ramsar Convention, an intergovernmental wetland treaty with 170 countries. So and I could go on and on really about all he has done at both the national and international levels. We're delighted he's here today to discuss his new book. So we'll get to the focus of today. Waters of the United States, POTUS, SCOTUS, and WOTUS, and the Politics of a National Resource. This book explores a history of the Supreme Court's efforts to define the Clean Water Act's jurisdictional reach. The book examines the ongoing power struggle among the executive branch, the courts, the states, and Congress over who gets to decide that jurisdictional reach and who really gets to decide what bodies of water are protected as a result. I'll just end by sharing a quote from one reviewer I thought was nice. An ecologist and past president of the Society of Wetland Scientists says this about the book. This book is a must read for anyone interested in the history of protecting US waters and wetlands and in safeguarding the country's waters in today's political landscape. Royal Gardner shares his masterful knowledge of law, science, politics, and history through witty and entertaining storytelling that will keep the readers turning pages. So quite the endorsement. So please join me in welcoming.
Thanks so much, Shannon, and thank you to the Hubbell Environmental Law Institute for facilitating this. Thanks, Jen, and especially Blake for facilitating all of this. And also, I want to say special thanks to Dave Squirtney, who really was the impetus for this visit. Before I get started, how many lawyers, law students, people affiliated with the law are here? Okay, all right. How many of you have worked on wetland issues? Ah, good. All right. Excellent. So, all right. So this crowd knows, that POTUS and SCOTUS are acronyms for President of the United States and Supreme Court of the United States, and that actually it was telegraph operators in the late 1800s that used these acronyms. WOTUS came along a little later, Waters of the United States. So you know that Waters of the United States is a statutory term from the Clean Water Act. If a water is considered to be a WOTUS, then it is protected to some degree by the Clean Water Act. At least a federal permit needs to be issued before pollutants can be discharged into that water body. If a water body does not qualify as a WOTUS, then it's left to the states or local governments to protect or not to protect. My goodness, who brings a baby to a lecture? That's my grandson. So this is so you can say whatever he wants. Well, this is me in one of my favorite places in the world. It's in the Western Everglades, Big Cypress National Preserve. I like to take my students there on a swamp walk every year, go chest deep into a cypress dome. It's quite cathedral-like to enter this the dome, and it's and yes, there are alligators there, and so it's very life-affirming to emerge from the cypress swamp with all of my students. So I have not lost any yet. That's why the administration still allows me to do it. So is this a WOTUS? We'll see. But first, I want to establish my environmental credentials. So this is a picture from when I was in second grade, when I won a photo essay contest at Gayhead Elementary School. Go Grizzlies! And the theme was man's use and abuse of the environment. But this is before the enactment of the Clean Water Act. And indeed, I was a two-time winner. I won the next year as well. And also in this picture, the impish one is my younger brother, and the non-brownie is my sister. And we had a bit of an unfair advantage because our dad worked for Kodak. So, and it is a shame, though. It is a shame that this is not in color, because in my memory, my short sleeve turtleneck is sky blue. It was the 70s. It was a simpler time. Jumping ahead a few years, I was actually introduced to WOTUS issues in an odd place, in the Pentagon. So I went to school on an Army ROTC scholarship, and then the Army was kind enough to allow me to go to law school first and work for a judge before I got picked up for a program in the Army General Counsel's office. And our clients were the Secretary of the Army, the Assistant Secretaries, and their staffs. And so we advised them on a wide range of legal and policy issues. And my principal client was the Assistant Secretary of the Army for Civil Works, who oversees, or I like to say, attempts to oversee the U.S. Army Corps of Engineers. And the U.S. Army Corps of Engineers has, since the 1890s, a regulatory program dealing with waters to keep navigable waters, traditional navigable waters like rivers, open for commerce purposes, but also in the early days for military purposes. So I actually got involved with navigable water issues and Clean Water Act issues in the Pentagon. I also had some international issues that I worked on as well. I was in the Office of Secretary of Defense for a time working on the Nunn-Lugar program, which is also known as the Cooperative Threat Reduction Program, where the United States was providing assistance to the former Soviet Union to help safely secure and dismantle their nuclear weapons. Not wetland related specifically, but certainly tangentially environmentally related. And at the international stage, as Shannon mentioned, I've worked a lot with the Ramsar Convention. And so I served as chair of the scientific advisory body for 2 terms. And that was just a great experience to be able to work with folks all over the world on wetland issues. So in terms of the book, I started writing the book in 2022, the photos from a year previously, but this is where my wife's family has been going for more than 50 years now. It's on the Rhode Island shore. And so part of the family stays over on the beach side. We're over on the wetland side. And so this was actually the view from the deck where I started writing the book, because this was in the summer of 2022. We were on the cusp of the 50th anniversary of the Clean Water Act. And I thought, what the world needs is a book about a statutory term, right? That's what everybody wants to read about. But it's interesting to me, but it might be interesting to other people as well, because it's not just a statutory term, or to get into it. We're going to talk about the tension between private property rights and environmental protection, between the relationship of the federal government and state government, and the relationship between the 3 branches of government at the federal level, all in terms of trying to deal with the issue of water quality. So why is there a need? Why can't the market just solve this, right? Why is there a need for any federal involvement with water quality in the first place? Well, even though I come from a law school that is known for its advocacy, trials, litigation is not an effective way, really, to implement policy. It's expensive, it's inefficient, and it's after the fact. So really, to deal with water quality issues on a systemic basis, you need to have some type of regulatory program. And initially, the responsibility was the states. This was viewed as a responsibility for state and local governments. But in 1972, Congress stepped in and enacted the Clean Water Act because the states simply were not doing a good job. And this is an emblematic photo of the Cuyahoga River, the debris on it on fire, and this occurred not infrequently. And so it was a race to the bottom. States were not doing their job in terms of actually protecting their citizens. So Congress in October of 1972 passed this law, this revolutionary law, the Clean Water Act, which prohibits the discharge of a pollutant from a point source to a navigable water, We'll get into what that means in just a minute. But it was quite remarkable that Congress did this in October of 1972. It actually overrode President Nixon's veto. So he is about to win a real landslide. I mean, more recently, people claim landslides and mandates. He actually took 49 states. 49 states, and a month before he did that, Congress overrides his veto. It was back in a time when Congress actually protected its constitutional prerogatives. And that was not a supine institution with a backbone of mashed potatoes. But what was also remarkable was that this is a month before a national election. These folks are up for re-election, and they're still legislating. They're still working. The government is still operational. It's functional. It was a simpler time. So they come out. They say, "All right, we're going to establish federal permit programs. You cannot discharge pollutants to navigable waters without a federal permit." The agencies that were given the responsibility for the permitting were the EPA. The EPA took care of the Section 402 program, the DIPD's permit program. So basically, pollutants coming out of the end of a pipe would be EPA's responsibility. For the discharge of dredged or fill material, you're going to be filling in a water body. The Corps of Engineers said, "Hey, we've had a regulatory program since the 1890s. We'll take that." Also, the Corps didn't want the EPA dealing with its civil works program, but yeah, we'll put that aside. So Congress creates this program where you have EPA and the Corps of Engineers issuing these federal permits, but there's a concept of cooperative federalism here. Clean Water Act sets a minimum floor of protection, and the states, if they want to, can take over the permitting responsibilities. They can assume the responsibilities as long as they are doing so in compliance with the federal minimum. And states are also free to regulate more strictly if they want to. So how is navigable waters? Well, navigable waters, traditionally what we're talking about are waters that are used in commerce in some way. And the Clean Water Act does use the word navigable waters. But there was a dispute or a difference between the House version and the Senate version. The House version defined navigable waters as navigable waters of the United States. The Senate version dropped the navigable modifier and just defined navigable waters as waters of the United States. And that's what passed. And the conference report called on the agencies to regulate waters to the fullest extent permitted by the Commerce Clause. So ultimately, after a few series of rulemakings, here is what the Corps and the EPA were regulating on the landscape. You had your traditional navigable waters such as rivers, territorial sea, wetlands that were subject to the ebb and flow of the tide. But then also wetlands that were adjacent to a traditional navigable water. And they also included non-navigable tributaries and wetlands adjacent to those non-navigable tributaries. And then in the top center there, they also covered so-called isolated waters, so long as those waters had some connection to interstate commerce. Scientists that I work with chafe at the characterization of waters as isolated, because they're not truly isolated on the landscape. But in the law, we like to put things into boxes. But there's no direct hydrologic connection to larger water bodies. So this is what the Corps and the EPA were regulating, and this led to litigation. So there were actually 3 Supreme Court cases in about 20 years that focused on this statutory term. The first one dealt with wetlands adjacent to a traditional navigable water. And in the case of Riverside Bayview Homes in 1985, the court unanimously said it was reasonable for the agencies to assert jurisdiction over these waters, to protect these waters under the Clean Water Act. And the court deferred to the agency's technical and scientific expertise. I pause for a moment while you think about those times of yesteryear.
Stefan?
It was it wasn't cited specifically, but it was the undercurrent, yes. So jump forward a few years, 2001, and then the court was considering isolated waters, at least whether the presence of migratory birds at isolated waters provided a sufficient Commerce Clause nexus. And this was the case of Solid Waste Agency of Northern Cook County. Now, I know some of you in the audience are probably saying, birds, they rarely buy anything. So how are they involved with interstate commerce? Well, people like to wait. I was sharing a table with a birder. Where is he? You just stay for the food. Right back there. Yeah. You know, birders, right? You know, people will spend, cumulatively billions of dollars a year going to visit different places to observe birds. Hunters as well, right? So, different type of birder. They will, they spend billions of dollars a year to go out and shoot birds. So what's the commerce nexus to some little isolated water? Well, cumulatively, if you remove these areas from the landscape, that is going to have an effect on bird populations. If you get rid of their habitat and now they're crowded into spaces where disease can spread more readily. So there is actually a commerce nexus, but the Supreme Court said, this is starting to tread into an area that's traditionally the province of the states, local land use decisions. And so we think that Congress has to speak more clearly if it actually wants the federal agencies to intrude into these matters usually left to the states. And so by 5-4 decision, the court said it was unreasonable for the agencies to assert jurisdiction over these waters, at least based on the presence of migratory birds. And that brings us to the 2006 case of Rapanos. How many of you are familiar with Rapanos? A few of you. Okay, so Rapanos, there was no majority opinion. You had Justice Scalia. He and 3 other justices had a very restrictive view of what the Clean Water Act should cover. You had 4 justices led by Justice Stewart that had a much broader conception of Clean Water Act jurisdiction, what constitutes a WOTUS. As long as it was hydrologically connected, that was sufficient for these 4 justices. And then in the middle, you had Justice Kennedy. Justice Kennedy didn't agree with Justice Rapanos and his gang, didn't agree with Justice Stevens and his gang. Instead, he came up with his own test that nobody agreed with, but it was his test. It was the significant nexus test. And in his view, he said, well, a water, if there is a water that has a significant nexus to a traditional navigable water, then it qualifies as a WOTUS. So if it contributes in some way or influences the biological, chemical, or physical integrity of the larger water body, then the feds can protect it, or at least require a permit before it's filled. He felt, okay, well, the lower courts didn't apply this test, so I'm going to join Justice Scalia and send it back down. So there was no majority opinion. No majority opinion. So what are the That was Scalia's, that was okay. So he comes up with the significant nexus. So then, you know, what are the agencies to do after this? There's no majority opinion. What do you do? Well, they initially issued guidance and they said, let's adopt a significant nexus test, which was reasonable. If I were there at the time, I probably would advise them to do that, because if the ideological composition of the court doesn't change and you have a water that satisfies Kennedy's test, you've got Kennedy and you've got these four. If it doesn't satisfy Kennedy's test, well, then, you know, you got Kennedy and these four. So the agencies adopt this significant nexus test, but they don't go through a notice and comment rulemaking. They just issue guidance. And so administrative law fans, you know that agencies can issue guidance without going through public notice and comment. Actually, they gave public comment. They solicited comment on it ultimately, but it wasn't codified in the CFR. So it wasn't legally binding. Didn't have the force of law. And so for many years, environmental groups, regulated industries, they were like, hey, you know, we want more certainty here. We want more certainty. So the Obama administration comes in and say, okay, we'll give you certainty. And the regulated community said, we don't want that type of certainty. And the certainty that the Obama administration did was basically enshrine in regulation this significant nexus test. But the rule also created some distance-based rules saying that, okay, if you have a wetland within a certain distance of a traditional navigable water, you don't even need to do an individual significant nexus analysis. We're categorically going to say it's jurisdictional. And then if it's beyond a certain area, we're not going to consider it. We're going to say it's non-jurisdictional. But as I said, the regulated community, they wanted certainty. They wanted the certainty of no regulation, or at least no federal regulation. Lawsuit was brought, and much of the Obama rule was enjoined. There's a really complicated history of it. I go into my book, so for those of you who are WOTUS nerds, you'll love that. Others, you can maybe just skip it. Trump administration comes in, and after an unsuccessful attempt, ultimately repeals the Clean Water Rule and comes up with its own rule, the Navigable Waters Protection Rule. And indeed, one of the first things President Trump did when he came into office the first time was to issue an executive order saying, I want the agencies to issue a rule on WOTUS that is consistent with Justice Scalia's plurality opinion in Rapanos. And so ultimately, the agencies did do that, but this too gets struck down by the courts as being, at least lower courts, as being inconsistent with the objective of the Clean Water Act, for a failure to consider the scientific record and for failure to consider the impact on those waters. So, you know, elections have consequences. We're moving back and forth, right? And so the Biden administration comes in. Biden administration says, well, okay, we'll issue a rule then, which is remarkably similar to the Obama rule, but without those distance requirements. But meanwhile, while that's going on, we have this other case percolating up from Idaho, Sackett versus EPA. So the Sacketts had some property that was about 300 feet away from Priest Lake up in the panhandle of Idaho. Anybody been there? I understand it's one of the crown jewels of Idaho. That's how it's characterized. So almost everybody considers Priest Lake to be a navigable water, except Justice Thomas. But we'll put him aside for the moment. Let's stay with me here, right? So let's assume that Priest Lake is a traditional navigable water. The Sackett's wetland was connected to Priest Lake by a shallow subsurface flow. Applying the significant nexus test, the agency said, well, we think that this wetland has a significant nexus to Priest Lake, and therefore it's jurisdictional, it's WOTUS, and the Sackett's are in trouble because they started filling it in without applying for a permit. So, case actually goes up to the Supreme Court once and then goes back up to the Supreme Court, and the Sackett's brief, the opening position, right, is a wetland is not a water. So the Pacific Legal Foundation, the group representing the Sackett's, they said, well, let's take a look at this statutory term, waters of the United States. Let's chop it up. Let's focus on water first, waters. And so they said a wetland is not a water. So this is me and my students standing in apparently what is not a water. There were many organizations that filed amicus briefs on behalf of the Sackett's. So this is small print. It's probably very hard to see from the back. Yeah, it is. But name an industry: home builders, ag, ranchers, chamber of commerce, oil, gas, mining, whatever. They're there. They want to gut WOTUS. They don't want to be regulated by the Clean Water Act. So who's in support of the EPA? Fewer. So you have some environmental groups. Also, you have a brief on behalf of 12 scientific societies. So I was the lead counsel for that, and we were trying to educate the court about the potential impacts of a restrictive definition of waters of the United States. So I actually attended oral arguments. This is my sister from that first picture. So she's a New York litigator, so she was on the brief as well. So we met in DC for to attend oral arguments. It was an interesting day in a number of respects. It was the first time the court was back open to the public post-COVID. It was also Ketanji Brown Jackson's first day as a justice. So there are several different lines, a couple of different public lines, and then there's a line for members of the Supreme Court bar. You want to make sure you get there early. So we got there pretty early in the morning. We were number 13 and 14 in line, and they only took 19 people from that line. So we were quite fortunate to get in to be able to hear the oral arguments. And when prediction going in was pain, but we were not optimistic. But after the oral arguments, I mean, especially Justice Kavanaugh, he asked some really insightful questions. He really understood the administrative record and the history of 7 administrations, Republicans and Democrats, regulating adjacent wetlands, defining waters of the United States to include adjacent wetlands. So we thought, maybe. But alas, it did not turn out that way. The court adopted the Rapanos plurality opinion, Justice Scalia's opinion, and started out by saying that waters are only those relatively permanent, standing, or continuously flowing bodies of water forming geographic features that are described in ordinary parlance as streams, oceans, rivers, and lakes. Where did this come from? It came from a dictionary. There's a whole dispute about what is the proper dictionary to use, but sometimes I think that justices just sort of pull whatever's on their shelf and use that. This one happened to be very convenient, though, because it was a narrower definition that fit the bill. But if you notice from the list there, streams, oceans, rivers, and lakes, what's not there? Wetlands. Wetlands are not there. Yes, wetlands are not there. And so the Supreme Court says, oh, okay, well, with respect to wetlands, Clean Water Act only covers wetlands if they have a continuous surface connection with a body of water that qualifies as a WOTUS in its own right, such that they're indistinguishable. And the court said, well, you know, we can distinguish between the wetlands on Sackett's property and Priest Lake, so that, you know, that we reverse. So what does the continuous surface connection requirement eliminate? So non-floodplain wetlands such as prairie potholes, precosins, vernal pools, Carolina Delmarva bays, gone. Ephemeral streams are out because they are not relatively permanent waters. So any wetlands associated with them are out, but really what's more damaging are the streams themselves, especially in the arid West, where 80 to 90% of the streams in the arid West are ephemeral. So those are no longer under Clean Water Act jurisdiction. And then wetlands that have only a groundwater connection to a WOTUS or a traditional navigable water, these are also out, right? And that's just based on the continuous surface connection required. Now, initially, environmental groups came out and say, well, you know, this is bad. It could be, you know, up to 50% of wetlands are no longer protected by the Clean Water Act. The EPA came out with a figure of 62%, although they've never actually explained how they came to 62%. But at the time, they were all trying to mitigate the damage. They were trying to say, well, maybe it isn't so bad. Maybe there's something left. But I'm here to tell you it's worse. It's far worse. Because the environmental groups and the agencies at that time didn't want to reckon with this notion of indistinguishable. They just wanted to say, well, indistinguishable, it's rhetorical flourish. Now, the court used the phrase indistinguishable or distinguishable 7 times. They used it with purpose. And so they said that the Clean Water Act extends only to those wetlands that are, as a practical matter, indistinguishable, right? Such that it's difficult to determine where the water ends and the wetland begins. What does that mean? We tried to explain that in our brief. We tried to alert folks, where I think we were the only one to really delve into this issue, to say it's not that difficult to distinguish between a wetland and another water. Wetland consultants do that every day. They can distinguish between the wetland and the stream, or the ditch, or the open water. And largely, it's, you know, it may depend on the vegetation change. If you can delineate a wetland, and you need to delineate a wetland if you're going to apply for a 404 permit. If you delineate a wetland, you're distinguishing it. If you're distinguishing it, then it's not a water of the United States. So this essentially, if you take the Supreme Court at its word, see no reason to suggest otherwise, this essentially wipes out jurisdiction for freshwater wetlands. And we tried to raise the flag, but to no avail. I don't agree with this. I don't think it has any basis in the statute. I don't think it's supported by science or practice, but this is what the Supreme Court has decreed. So, is the Cypress Dome one of my favorite places in the world to visit? Is this a WOTUS? How many of you think it's a WOTUS? Got one hopeful person. How many of you think it's not a WOTUS? Yeah, more, yeah, okay, all right. I would say no. Because this Cypress Dome, it will dry out for part of the year. So there is not a continuous surface connection. It's also separated from other waters by a road. And so you can make the argument that you can actually distinguish it as well. So I don't think that would be protected. Now you might say, well, all right, so it's in Big Cypress National Preserve. So it's protected, right? Actually, no. There are a number of different private property rights that have been reserved. But yeah, it is at least in a protected area somewhat. What about the larger Everglades ecosystem? What's the impact there? So this is some mapping that colleagues of mine at Stetson did, taking a look at what the shaded areas are wetlands that were jurisdictional before Sackett. So applying the significant nexus test, this is what they estimated was covered by the Clean Water Act. You want to see what it is post-Sackett? I'm sorry then. Oh! Doesn't look any better in color. So in my book, they didn't allow me to do color, so it's in black and white in the book. But you know, the impact is pretty black and white as well, right? It is basically like 98% of the wetlands would not be considered adjacent wetlands post Sackett, applying this indistinguishable requirement. And this is, I mean, this is not just Stetson saying this. Environmental Defense Fund and others have also done mapping exercises like this and have come to similar conclusions. So initially, I think the agencies and environmental groups were, you know, they didn't want to admit just how significant this decision is. So what are the downstream effects of Sackett? Well, it means there's no need for a federal permit, for a Clean Water Act permit to fill the vast majority of wetlands and many streams. Millions of miles of streams, millions of acres of wetlands no longer require a federal Clean Water Act permit. And this is even if they were the subject of a previous denial, I would suggest, because the Supreme Court here is not judging like it was in the previous cases about did the agency act reasonably in interpreting the statute. This is the Supreme Court saying this is the proper interpretation. This is the only interpretation. This is the interpretation the agencies are going to have to follow from this day forward. If you remove the need for a 402 or 404 permit, and this case was in the context of a 404 permit, and that's really where the irritant lies with the Clean Water Act. And in many cases, it's this 404 permit. But WOTUS, it's at the heart of the Clean Water Act. It also applies with respect to 402 permits. So if there's no jurisdiction for 404 purposes, there's no jurisdiction for 402 purposes. It also means that Section 401 water quality certification also does not apply. And then, of course, other federal laws are affected, you know, such as NEPA. If the Clean Water Act was the jurisdictional hook for a NEPA analysis, well, NEPA doesn't apply if you don't otherwise have any other federal action. A little more complicated with respect to the Endangered Species Act. If anybody wants to talk about that during the question period, we can certainly do that. Who else is sad about this? Wetland mitigation bankers. So I talk every year at the National Mitigation Banking Conference, which you're now calling the National Ecosystem Banking Conference. And you know, I deliver bad news in a humorous way. And if you were always predicting that the end of the world is going to come, you know, sometime you're right, you know, someday you'll be right. But you know, apparently they don't want me speaking on the plenary panels anymore, spooking their investors. Smaller rooms now, but we pack them in. We pack them in because they want to hear what I have to say, and they know that Sackett has heard of them if they are in states that don't have an independent wetland regulatory program, because those federal credits are worthless if there's no demand for them, and there's no demand if Sackett, if the Clean Water Act was the only driver for those credits. So ultimately, the responsibility for wetland protection has shifted to state and local governments, and that, I think, we can continue to try to work at the federal level, but I think really it's at the state and local level where we have the greatest potential to play defense or offense. Now, I knew from the first time I published a book with Island Press that they said, well, you can't just end on a bleak note. You have to give people some hope or some action items or something. So the last chapter, I open up with and every chapter I open up with a quote. I think my students like chapter 4 the best, that quote, because that one was, so that one is entitled Handouts to the States. And the quote is, "It's all about the Benjamins, baby." Puff Daddy, 1977. So when I wrote that, he wasn't indicted yet, okay? So the last chapter starts out with this quote. "The vote is a power, a weapon of offense and defense, a prayer." Carrie Chapman Catt, 1920. With a 5-4 vote, SCOTUS scuttled WOTUS. Millions of acres of wetlands and millions of miles of streams have been stripped of federal protection. The Clean Water Act's objective to restore and maintain the integrity of the nation's waters is now less a goal and more an unanswered prayer. The Supreme Court will not reverse itself. Congress has the ability to remedy the matter, but currently lacks the will. Executive branch agencies find themselves constrained by judicial decisions. Ultimately, it comes down to whom we elect for federal, state, and local offices. Suffragette Carrie Chapman Catt, founder of the League of Women Voters, recognized the importance of voting. Her statement made on the occasion of the ratification of the 19th Amendment is no less true today. The most effective way to ensure clean water for our current and future generations is to elect leaders who share that value. You might say, well, that's very nice, that's aspirational, that's Pollyannish. Does that really work in today's world? Well, let me give you 2 examples from Florida to perhaps leave you with a little bit of hope if you are on that side of the issue. So Manatee County, a county south of where I live, the county commissioners were considering a proposal to relax protections for mangroves, a type of wetland. So they're going to reduce the buffer zone for development with respect to mangroves. And a couple hundred people came out to a commission hearing and said, no, this is wrong. You should not do this. So what did the commission do? It went ahead and passed it anyway. And then the next election, all 5 were voted out. In part because of those actions, not listening to the people. At a statewide level, Governor DeSantis's administration came out with a proposal to install pickleball courts and golf courses and hotels in our state parks. That was met with bipartisan outrage. Part of it may have been pickleball, but it really had to do with the state parks. That there is bipartisan support for the protection of these jewels in Florida. We have some great federal lands, but we also have fantastic state parks. And so there were protests on the street with signs, bipartisan protest. governor backed down, they withdrew that proposal. But they can always come back, right? The legislature then passed a law to strengthen protections for state parks. And so the legislature was actually responsive to the people's concerns. So with that, thank you so much for listening, and I'd be happy to answer any questions you might have.
Questions, put them on the note cards and I'll come around and grab them.
No. Oh, you're moderating them.
Okay.
So
I'll get us started.
Yeah, sure.
Because we may have some students in the room with some exposure to the Endangered Species Act. And
Yes.
you said you might answer that question. I'll just start with that. How might the Endangered Species Act protect wetlands? How does that work?
Right. So SACIT, I mean, it's a case involving statutory interpretation of a term in the Clean Water Act. It does not affect the Endangered Species Act. And here's the funny thing for developers, right? Who may like the SACIT decision, is that if you needed a Clean Water Act permit and the property had some endangered species issues, the Corps could go through Section 7 consultation with the U.S. Fish and Wildlife Service, and the developer could get an incidental take statement to provide protections from ESA liability should the project then result in a take of a species. Well, if you don't need a Clean Water Act permit, well, the Corps is not going to do any consultation. So either you as a developer are going to take the risk that, well, if you go forward with your project and there's a take, you could be subject to civil and criminal liability, or you have to go through Section 10 and get an incidental take permit. And so rather than Section 7 consultation, which has defined time frames and it's the agency running interference for you, you as a developer need to go to Fish and Wildlife Service and negotiate yourself. And there's no set time frame. And so in some of the earlier cases, like with Swank, when Solid Waste Agency of North Cook County, when jurisdiction receded from some isolated waters, there were reports of developers coming to the Corps saying, please assert jurisdiction over these waters so we can go through the Section 7 process rather than the Section 10 process. But the Corps is like, sorry, you got what you wanted. So there's a complication for developers there. And actually the state of Florida also tried to assume the 404 program. So as you may know, almost every state has assumed the Section 402 program, partly because there was some federal money associated with it. Only 2 states had assumed the 404 program, Michigan and New Jersey. Florida was the third, or was attempting to be the third, but that has actually gotten followed up because they failed to do proper consultation when making that decision.
Great. I have a couple of really good questions here, and then if there's time, one more that I'd like to ask.
Sure.
So if an isolated wetland is on basically federal land, right? How does that work? This question is, shouldn't it be considered a water of the United States? Basically, it's not.
If it's on public land, no, it's not. Congress didn't define waters of the United States to mean waters on public lands. So waters of the United States has been defined just to be surface waters of some type. It doesn't cover groundwater, it doesn't cover aquifers, but it doesn't matter who the property owner is. That doesn't dictate whether it's a water of the United States or not. I mean, it is in a sense a water of the United States or on the United States property, but for Clean Water Act purposes, it's not a WOTUS. So then you run into the strange situation where you have Everglades National Park, which the United States has designated as a wetland of international importance under the Ramsar Convention, most of it is no longer a water of the United States.
All right, not surprisingly, given that we're here in Iowa, right? So there's a question from someone who describes themselves as a moderate Democrat and also a farmer. I think it's seeking your opinion on whether regulation has overstepped authority in defining wetlands in the past to not allow crop production, agricultural uses. So I'm thinking of your slide where you talk about the history. You might want to talk about exemptions.
So, I said, 1972 Clean Water Act was revolutionary in terms of rewriting federal-state relations with respect to water quality. After every revolution, there's a counter-revolution, right? And so the first battle in the counter-revolution was in 1977 when Congress amended the Clean Water Act, in part due to concerns from the agricultural community to provide statutory exemptions from the 404 program for ongoing agricultural activities. So that would include plowing, seeding, cultivating, harvesting. That's exempt. It's not covered by Clean Water Act 404 at least. The place where I see the greatest agency overreach or perception of overreach. I tried to explain this last night. I'm not quite sure how well it went, but I'll try again. I'll keep trying again, and that involves prior converted croplands, because there was a time where, all right, so what wetland delineation manual do we use right now for purposes of the Clean Water Act? It's Corps of Engineers 1987 delineation manual. At the time, you had 4 different agencies using 4 different manuals to define whether something is a wetland. And that's the first step to decide whether a wetland is a water of the United States. You have to determine, is it a wetland? And so that would take a look at, indicators of the presence of water, hydrophytic plant list, hydric soils. So there were 4 different approaches, slightly varying approaches. And so the agencies said, this is silly. Let's just have one uniform approach. So they actually locked each other. They went to like a hotel conference room and like worked for a week and came up with what was the 1989 manual, which met with universal outrage. I mean, it was an attempt of good governance, but it could be interpreted to cover agricultural lands that were in production, in the sense that in terms of dealing with disturbed sites, it allowed you to rely on just one indicator like hydric soils. I hope that's not the farmer. So that delineation manual caused a great deal of concern in the regulative community, and Congress actually passed a rider in an appropriations law telling the Corps of Engineers, don't use it, you got to use the 1987 manual. And so that's what the Corps has been using along with regional supplements ever since. So, okay, so wait, so do the farmers have a point? Well, the agencies then put into regulation a notice and comment rulemaking. They said, we don't cover, a prior converted cropland is not WOTUS. It's not WOTUS. Unless you abandon it, right? If you are engaged in agricultural activities at least once every 5 years and wetland characteristics return, then it might be a WOTUS. Right? So now, so that changed from administration to administration. So the Biden administration actually wanted to get rid of that 5 years. And so the ag community was up in arms. And yeah, it was a change, but it's not interfering with ongoing farming operations at all. It's not interfering with the family farmer. What it interferes with is if you stop agricultural production and then wanted to sell to a developer and wetland characteristics came back, then it might create an impediment or reduce the value of the property. That does not square with the rhetoric of the farm bureaus, right? That it's like, oh yeah, we want to protect, family farms so they can sell to developers more easily. But I think there was a legitimate point there. I think there was a legitimate point, and I was involved with the rulemaking with prior converted cropland, and my recollection, along with some of my other colleagues, is it's like that's it. If it's prior converted cropland, it's not going to be a WOTUS. So that's my answer for the farmer. Okay.
But this one's much easier.
Good. All right.
But it's a good question. Doesn't ignoring a significant hydrological connection through shallow groundwater, isn't that a rejection of hydrological reality? And so maybe this is a question about the Clean Water Act and groundwater.
Yes, it doesn't ignore hydrologic reality. Yes. Yes, it does. Yes, it does. In an earlier decision a couple years before, in a case called County of Maui, the court in a 6-3 decision actually recognized that discharges of a pollutant to groundwater, which is not a WOTUS, that migrated to a WOTUS could be regulated. But no, the court I don't think had a very scientifically sound decision in SAC.
So I'm going to use, since I've turned out to be the moderator, I'm going to use the privilege to ask the question I'd like your thoughts on. So many of us in the environmental law field were a bit surprised when the court, it looked like, was going to grant, cert and think about the significant nexus test, and it shifted to this notion of adjacency, right? And since you were involved in the, you were the lead on an amicus brief. Did that surprise you? Do you have thoughts on what happened and how we end up with a concurrence rather than a dissent in brackets?
Yeah. So it's interesting in Sackett in terms of the question of the significant nexus test. All 9 justices voted against it. Mm-hmm. Justice Kennedy actually was in the room. See, he didn't like it. So Justice Kennedy was actually in the room for oral arguments, and he got to listen to all of his former colleagues, question the wisdom of his opinion. So you had all of them agreed that the significant nexus test was not the way to go. You then had the opinion written by Justice Alito that had 5 votes. And that's the opinion I was talking about. And that this is unlike Rapanos, where there was a plurality opinion, so no majority opinion. And so that's why Justice Kennedy's concurrence in the judgment loomed large. Here we have a majority opinion. So the concurrences are less, they're academically interesting, right? But as a practical matter, it doesn't matter. So Justice Kavanaugh concurred in the judgment, but didn't offer his own test. We don't know what his test would have been. He just didn't like the test that the majority adopted. The 3 others, it reads like a dissent, but it's not a dissent, perhaps because they wanted to, it's a concurrence in the judgment because they wanted to support Justice Kavanaugh. So we don't actually get, from the 4 justices that did not agree with the Sackett approach, we didn't get an alternative. Now this is a question of statutory interpretation, so the court's not gonna go back and revisit. When the Supreme Court is dealing with constitutional matters, it may from time to time go back and revisit its decisions because it's the ultimate arbiter of the Constitution. But the Supreme Court feels if it misinterpreted a congressional act, Congress can remedy it. So the Supreme Court is not going to reopen WOTUS again.
Right, well, I think so that we don't end up upsetting the next class, we should begin our transition out. So thank you.
Very much for all of your hospitality and your wonderful questions, and I've had such a great time in Iowa. I feel that I am now morally compelled to root for Iowa football.